a well-educated black has a tremendous advantage over a well-educated white in terms of the job market. And I think sometimes a black may think that they don't really have the advantage or this or that, but in actuality, today, currently, it's a great, I've said on occasion, even about myself, if I were starting off today, I would love to be a well-educated black because I really believe they do have an actual advantage today.
What's being black in America mean to you? Well,
into the fact where the victim is now the perpetrator and the perpetrator is now the victim. And that just drives me crazy. Come up on me, I'm plugging the mic in because I'm an idiot. But I'm a lovable idiot. And the mic is up, I'm up, and welcome to 30 Frames a Second. My guess is Alton Maddox. I told you we were going to bring Alton Maddox back. We still have to finish the series we did with the history of Alton Maddox. But right now we're going to shoot right to current events. And we wanted to start off with Donald Trump's analysis of how advantageous it is for educated blacks. We also want to make special note of the time period because the time he made that statement is September 5th, 1989. So I think it was a few months later when he put out the full-page ad about the Central Park jogger kids. With that, I'm not going to even ask him a question. The only question I'm going to ask of this gentleman here is, what do you make of that and bring us into today? Alton, it's a pleasure, brother.
Pleasure is mine as well. Thank you, Nat. In 1989, actually, in April of 1989, there was a rampage throughout Harlem looking for persons who may possibly be suspects in the so-called Central Park jogger case. And at some point after that, those young men, 8 of them were actually arraigned. They called themselves the Central Park 5 today. But there were 8 young men who were actually arraigned. So they were actually brought into court. And of that 8, 1 young man was actually, his case was dismissed in court that day on the arraignment. And there was 7 other young men. I represented one of those 7, and eventually the client that I represented was in fact dismissed. His case was dismissed. And so after that, Donald Trump, without any intention on our part to bring him into the case, he brought himself into the case and actually started his campaign for the presidency on the backs of the young men.
Right.
And so he had a tremendous amount of influence in terms of their wrongful convictions, because actually the media just went crazy, you know, as they're going crazy today with him in the quest for the presidency. And it was just too much for anybody to overcome. I mean, the jury pool was automatically poisoned.
Right.
As a result of this man and the statements that he was making against some innocent young boys. But this was of no moment to him. He's doing the same thing today as he was doing then. He's operating his own best interest and not in the interest of anybody else. And this what became of his quest.
Now, this was a time, those of us who are old enough to remember the late 80s, going into the 90s, would have to remember that this was a very challenging moment in history for the African American community and people of the African diaspora in America, especially in New York City. At the same, and also there was no internet, there was no Twitter, there was no Facebook, there was no cell phone to send messages out. The printed media, the Daily News, the New York Post, the printed media had a tremendous effect on what people saw and believed to be true, and inciting masses of people to move one way or another. So when he took out an ad in the paper basically declaring that these kids were guilty, they were animals, they were atavistic at best, and deserved to be basically expunged from humanity, it had a tremendous effect. And we didn't control newspapers, so there was no counter to this type of rhetoric from our part that even came close to what was put out.
And you have to also remember that it was also a time when you had Mayor Koch in Grayson Mansion, and he was not kind himself to black people.
Correct.
And so, you were running against all of the racism that, really was here to address these young men. And they just literally had no possible chance of succeeding. But that was of no moment to Donald Trump, because his interest was obviously somewhere else. And while a lot of people may not have seen it then, it was very clear now as we look back that he was actually campaigning on the backs of these young men for the White House, and nobody saw that coming. And so when he announced some 20-something years later or so that he was running for the presidency, he had really much laid the groundwork for much of what you have to do to become the president of the United States. He had actually done it. And while he doesn't necessarily put a lot of attention on black people at this moment, he doesn't have to, because everybody's already know in their own mind where he stands as it relates to us. It's just a matter of going after others now, and that's what he's doing.
Now, in 2016, there is no mirror because there is no buffer, because he actually is running for the presidency of the United States. He's garnered the Republican, enough delegates to become their candidate,
right.
As the rules stand at this moment. He's also proven conclusively the efficacy of racism and racist rhetoric in terms of gathering a significant portion of America to support him. You wrote an article not too long ago that I read that you sent out, and it was about there's only 2 states in America that actually prosecutes children, and that is New York and North Carolina. Am I getting that wrong? Expound on that, because these were little baby-faced kids that America was calling for lynching, for lack of a better term.
Well, it's also very interesting now when people look at it that you had most of the cases against young people actually happened here in New York. I mean, we think about Central Park 7, then we think about Tawana Brawley, and we think about a number of other cases. It's just a matter of connecting the dots to recognize that this has really been a major problem in New York for a long period of time. Now, fortunately for me, I really became acquainted with this problem actually in the early 1980s. And that's when I became the director of the Juvenile Defense Project. And at that particular time, New York was importing the South African law against young children. And it had been enacted in South Africa to put down the Soweto uprisings. And so now this law is coming into New York and having a very draconian effect on the lives of young people.
By South African, you're referring to apartheid.
South Africa, right. And so this was during that period when the New York legislature, talking out of both sides of his mouth, obviously, saw the way that South African treated young blacks as the way that New York should treat those blacks as well. So I somewhat had a head start on other people, you know, in terms of really seeing the problem, because in addition to that, I also had an opportunity to study the juvenile justice system throughout the country, and, you know, had been in various other parts of the country looking at it. And so I saw that New York and North Carolina was taking a very different approach to the way our young children are being prosecuted. And so obviously when the Central Park case came up, I happened to probably be the only lawyer who represented anybody in that pro bono, you know. And so, but I realized what the problem was. Unfortunately, we could not get enough other attorneys to get involved to try to put a handle on this thing. But in any event, you know, I just felt the compulsion to have to at least take a lead role myself in it, because, you know, usually when you think of young people, you usually think of family court and all of that. Right. But in New York, when a child reaches 16 years of age, here the child is treated as an adult. Now,
in criminal court.
In criminal court, the child is treated as an adult. And so what people fail to realize is that 48 other states have taken a different approach. I mean, so New York is in a very slim minority. The only other state that rivals New York is North Carolina. And so, you know, when you see that, you know, you have to really be concerned about our young people and what has happened to them. I mean, because it actually destroys the fabric of the lives of people when children as young as 16 are being prosecuted in adult courts. Constitutionally, what people fail to realize is that in those other 48 states, a person 18 years of age is also able to vote.
Right.
So by being able to vote, that person can have some choice in terms of who might make a good candidate or not. But in New York, at 16, you can't vote.
Correct.
So
Correct.
Therefore, it's even worse here, because now you are depriving children as young as 16 the right to be heard if they're going to be prosecuted. And this is a serious problem.
And correct me if I'm wrong. You're the legal mind. I'm just the guy with all the questions. But correct me if I'm wrong. The same 16-year-old who can be tried as an adult in criminal court, if they got hit by a car, they are basically listed as an infant, and it goes to the. Am I missing something, am I incorrect?
No. In fact, you really raised an interesting question, because what people fail to realize, this was the problem with Tawana Brawley. Tawana Brawley was not even 16 years of age, much less 18 years of age, and could not be represented by anybody in court because she needed a guardian ad litem.
Right.
Now, New York denied her the right to have a guardian ad litem. In fact, she never got a guardian ad litem, and yet and still, at the end of the day, the state is claiming that Tawana Brawley is liable for all that had occurred, and she never got an opportunity to be heard herself. And people never look at that. You know, people say, well, why don't Tawana talk? Tawana can't talk. She was a child.
Right. Children
don't talk. And so at 15, she had no obligation to talk. And this is what people miss. And this is where the problem of a lack of understanding of legalese comes about, because she had no reason to talk. And I certainly was not going to allow her to talk because even adults.
She didn't have a chance.
Even
Adults don't have a chance.
Even
in the
adults
legal
don't
system.
have
Right,
court in
right.
the legal
You don't have a
system.
chance.
Yeah,
You
right.
don't
So
have a
you know, I
chance.
certainly wasn't gonna put a child,
right.
you know, in harm's way.
Right.
And so you know, it's some serious problems that we had to look at in the state. You know, some very serious problems, and they're so serious that I have petitioned both the governor of this state and the U.S. Attorney Preet Bharara to actually, you know, take a very serious look at this, especially in terms of Cuomo, because I think if there's anybody should be behind bars, he should certainly be the one that goes behind bars. He certainly should be as much behind bars as Sheldon Silver and the other guy that head of the Senate majority. And so we're going to have a triumvirate, as people call this state a triumvirate, means 3 white men sit in a room and make decisions about the lives of everybody. Then I don't know why he's not being prosecuted himself.
I also don't understand why this has not been hashed, brought up, argued in the decades subsequent to Tawana Brawley, because the Tawana Brawley case represents one of the most oxymoronic sacks of BS in terms of how they punished and prosecuted Tawana Brawley and you, legal counsel, in spite of the fact that none of it makes any logical sense. How they were able to get a judgment against a person who was 15 years at that time, a judgment where they could actually go into her bank account till doom cracks, based upon something that was the whole thing is madness. And again, the fact that you can prosecute a 15-year-old, but a 15-year-old as a litigant has no rights and privileges, and you can punish a 15-year-old based upon something. It's even worse because you're punishing that child on litigation that they had no voice in at all at the time. It's just oxymoronic madness. I mean, am I missing something?
No, you're not missing anything at all. I mean, in fact, that was the reason why I just said, look, you know, if I have to just simply lose everything, I will, because this is just absolutely wrong. I mean, you know, this doesn't make any sense at all for this to be happening in any period of time, and certainly doesn't make any sense for it to be happening now, where you can essentially, not only with Tawana Brawley again, but with the Central Park 7, just really convict people on public opinion, you know, without any due process,
Correct.
without any right to be in court to challenge the evidence or anything. This is just what is happening
Correct.
here.
And
this
sentence them.
Right,
Not just convict them on public, sentence them and punish them.
And punish them. And then
in perpetuity.
In perpetuity. And then you have people, you know, you look at things today where you see a situation where young people, what they talk about, if you go to jail and all of that come out, now you can't get into public housing, all these kinds of things, you know what I mean?
Right.
So, you know, it's all kinds of ramifications.
Right.
I mean, they have to seriously be looked at.
Right.
And I felt as though, you know, look, for me, I mean, to call myself an attorney and to go along with this is something that's just way beyond me. I just can't do it. You know what I mean? That's just not the way that I see things, because this is just totally unjust. And at some point, it would seem as though other lawyers just have to raise up and say, hey, man, we just can't have this as a system of government. This is just not working.
And that's the thing that I probably understand the least, because if you analyze the economics of the black community, the black community is probably poorer than at this point in time than it has been at any time since probably Reconstruction. And we don't have the outlets that we had for entrepreneurism, for self-determination, for self-development of our communities that we had in, say, 1917, 1921, 1920. the cost of living has gone up exponentially to a degree that people who make money can't afford it. And we aren't making any money, and we're losing our communities. We used to have a legal aid system that actually protected people, protected poor people, especially people of color, in say instances of housing or any legal instance. We don't have that anymore.
Well, you see, this is what I believe. And I think this year is the time for us to really go back and do what should have been done more than 150 years ago. And that is this. It's a very simple thing, but people somewhat overlook it. And that is that, you have to transition from slavery to capitalism. You have to transition, and in order to transition, you have to first have an orientation, because that's the only mechanism that allows for people to transition. I mean, and if you go to prison, you got to make a transition to prison. There's orientation. If you go to the military, there's a transition to the military life, and that's an orientation. And there's no way in the world that our ancestors could have transitioned from the plantation to capitalism without A, an orientation, and B, some net worth. Because you have to have some capital in order to function. I mean, it's like, going to the casinos and not giving any cards or any chips in order to play in the casino.
Right.
You just can't function. So my point is that it's very critical.
Or worse still, never having any experience with any of these games, and somebody give you a lot of capital.
Right. Right. Well,
advance your capital that you now are responsible for, and drop you off in the casino.
Right. That's it. That's how ridiculous this whole thing is. And so my point is that, I would love to see us have a crisis at the Republican convention and the Democratic convention. You know what I mean? Because I think that's the only way we can correct all of this. I mean, people got to deal with the hard questions, that we are facing. And actually, October 3rd, 2015, I had what was called a planning conference for a national black political convention. And we held it in Washington, D.C. at the Galbraith AME Church in Washington, D.C. And the significance of October 3rd is that with the power of their ancestors, I foresaw the issue in 2016 as being that of immigration. I mean, that's what I foresaw. So I chose October 3rd, 2015, because that was the date that Lyndon Johnson signed the 1965 Immigration Act. And so 50 years later, this is where we are. So I felt like, this is where we have to start, because now we start talking about immigration. We're not talking about everybody else, but we're also talking about our own ancestors who weren't necessarily immigrants, in the traditional sense of the word, but they were brought here from against their will to this foreign land. And so in that sense, when you look at Dred Scott, I mean, that's what you're talking about. He talked about we're not citizens and all of that, I mean, all that's part of this whole question of immigration. What Donald Trump is preaching now is original intent. Donald Trump is saying, look, we need to go back to where we were when this Constitution was signed, and everybody should go back to their inferior position.
Their role. Right. Know your role.
Right. I mean, that's what he's preaching. You know what I mean?
Yeah.
And so, I think we're in a very critical moment now. I don't think we really have any more time to waste as a people. I think these are very critical, and we have to be very precise in what we're going to do, because we're laying the future for whatever is going to be here. We're laying the future for it, because even Dr. King and those, as much as they tried, they still fell short in a lot of issues. I mean, like, for example, we took it that as a result of the civil rights movement, that we were actually citizens of the United States, but we were not. Because, you see, what Dr. King was able to get from this country after all those years of battle was a reversal of the civil rights cases of 1875. But the reversal of those cases ended up in the Congress deciding that we were still not citizens and that we were actually able to go into these public facilities, the hotels and all those places that we frequent now, not because we were citizens of the United States, but because we were engaged in commerce. And that's a whole different ballgame. I mean, we've always been engaged in commerce. You know what I mean?
Right.
So
we are commerce.
Right, we are commerce. All right. So for that to happen requires us now to seriously reconsider everything that has gone forward. Because the idea of Donald Trump and Hillary Clinton is really a mirage.
I know.
You know, it doesn't solve the problem at all.
There's a meme that's going around about Donald Trump and Hillary Clinton running, and it basically has a picture of Donald Trump and a picture of Hillary Clinton. And the meme is, would you like your racism, do you want your racism blatant or systemic?
Right, right. No, and that's it. That's
Right,
real. That's
right,
real. And
right.
we had to, at this very moment, wherever we headed, we got to do it right now. You know what I mean? Because we talk about the future of ourselves, we talk about the future of our children, we talk about the future of this country. I mean, that's what it all boils down to. We at the crossroads. I don't know what people realize this or not. These are the crossroads. And it's very interesting that both candidates are out of New York.
Right, right.
Both candidates are in New York.
Right.
And so, all of the problems that we have here in New York, we can foresee those problems mushrooming throughout the country.
Right. And both have an unprecedented appeal to southern to a southern base.
Right.
Hillary Clinton portends to be from New York by way of Arkansas, and Donald Trump is like the hillbilly king.
Right.
And both of these people are so far removed from Southern life. I mean, they're more removed than I am growing up on fish and grits.
No, they are. They really are. And I think the other thing that we have to do is to realize to go right back to the Compromise of 1877. Which I think is a very critical moment because that was a time when Hayes and Tilden, agreed that we were going to withdraw the federal troops, stop any protection of the newly free Africans in this country, and put them right back to where we found them before they saved the Union, And so I think we're going to go right back to that, because we're talking about political cycles here. And basically, that is a political cycle. I mean, the politics is such that things run in cycles.
Right.
And when you really look at this whole notion, there's a political cycle that has culminated from 1877 to 2016, and we have to be very clear about the fact that that's a cycle that we have to deal with right now, and it's going to really portend where this country is headed and where we're headed with it.
Now, in your writing, you alluded to the fact that basically our slave mind and our slave existence. You alluded to Muhammad Ali actually selling his legacy, his estate in 2006 to a Jewish guy. So he doesn't even have that legacy.
Right.
And you alluded to a few other things. And
Rosa Parks sold her legacy.
Correct.
Right.
And very few people are actually addressing the fact that we have to divest not only from white supremacy and the white supremacist system, but our own mental ties to that system that keeps pulling us back. I find it very interesting that in 2016, a generation of young people who are very resentful, who would curse you and fight you every step of the way if you refer to them as black, are so comfortable with people calling them nigger. So much so that they make excuses of why you shouldn't say anything contrary to my white movie star friend who tweets, you know, I'm with my niggas.
Right.
I think that is a tie that somewhere in our slave mentality we have just put too much emphasis on assimilating and voting, and not enough emphasis on reclaiming who we are.
Well, you know, one of the things that I did, because I think it's very important, you can't really understand our plight unless you really understand legal history. And that means having a very close examination of those Supreme Court cases that we now tend to live by. And one of the things, one of the problems with it is that legal history is really not taught in law schools. You know, it's more a legal hobby rather than a legal history, you know, that is taught in law school. And so you don't really get the full glimpse of what is going on in these cases, you know, because law schools teach about the case method. And so when you look at the case method, they have actually been sanitized. And so a lot of the horrors, you know, that relates to what a litigant may have incurred are no longer in that case. So you sitting there in law school and you look at a case like Gaines versus Missouri, which was one of the earlier cases of desegregating law schools. And basically Gaines, Lloyd Gaines, out in Missouri, who wanted to go to law school out there, and sued and was successful in doing it. All of a sudden, nobody finds Gaines, but that's not really reported in the legal annals. The fact that Gaines was actually murdered. So you know, now when you look at and read this case, you know, you're not really looking at the lynchings that the person suffered around the case. So you can't truly understand the real horrors of the case. All right, you know, same thing with, for example, and I think this is one of the worst cases. It sort of was a precursor, but I think one of the worst cases was Brown versus Board of Education. And so here in Brown, you know, in law school, you know, you're dealing with a particular litigant who was actually Briggs. You know, it wasn't Brown. It was Briggs versus Elliott. I mean, that was the lead case. Now, Brown versus Board of Education came out of Topeka, Kansas. Briggs versus Elliott came out of South Carolina. So to sanitize the case, there was a bait and switch. So now you have Briggs versus Elliott becoming Brown. It submerged into Brown versus Board of Education. And Brown was out in Topeka, Kansas, where, you know, it wasn't that bad. I mean, there was segregation, but it wasn't a whole lot of lynchings and night riders and all that went along with what happened out in Topeka.
South Carolina is, you know, historically significant in just about every aspect of the American slave
and so
identity.
And so what happened was, now when you read this case, you don't understand, for example, that the judge in South Carolina, a guy by Wadey Warren, was the one who told Thurgood.
Fix your tab.
Okay.
Was too important not to look good.
Was the one that told Thurgood that you need to change the legal question here. You see, instead of talking about the right of blacks to have transportation to get to school, you need to start talking about the right of integration. So, you know, and see, this is what had not happened with the whole case of Charles Hamilton when he was really the architect of all of this, because he foresaw we should not put our babies in these schools. We're striving for some desegregation, but we should not use our babies, you know, as a sacrificial lamb. Instead, we should allow the adults who are in graduate school to attack this rather than use our babies as the plaintiffs.
Let me ask you a question, and I don't want to get off the track. I want you to get back to what you were saying. Let me ask you a question, because you talked about the right to integrate for integrated education. But was it argued about the right of integrating the school system, or the necessity of integrating the school system? Because and when I say necessity, I mean in terms of equal education opportunity. Because to me, they are two separate things. My right to go to an integrated school system, to be admitted into any school, is different than me saying that by definition my school system would be inferior. And it seems like we argued the necessity for integration as opposed to a God-given right to go to any school that are tax money funded. Am I way off base, or
No, you're not way off base at all. As a matter of fact, you know, basically the proof that was put before the Supreme Court was actually Dr. Kenneth Clark here in New York, I believe, claiming that there was a dog test, and that in this dog test, it showed that black children did not like their own color.
Right.
And so Dr. Clark,
Right.
used
and that's
that.
an understatement.
Right.
That it showed that black children assumed the worst in every aspect
Right.
when it came to blackness. That if it's black, it's more likely to steal, it's uglier, it's less trustworthy, just the whole gamut.
Right.
You
Now,
know.
and you're absolutely right. And this where the problem was. See, the advocate for the South was an advocate by the name of John Davis. And John Davis was actually the foremost litigator in the U.S. Supreme Court. And he had been hired by the South to oppose what the NAACP and other groups were doing. And the NAACP, obviously through Kenneth Clark, was making this argument about, black being distasteful and children embracing that. And, Clark and David was saying, well, that's not really true. He said, because the argument that you're making is not based on the scientific facts in the case, because what you've done, you have used a statistical sampling in South Carolina, an unscientific sampling in South Carolina, whereas Dr. Clark had actually conducted a very scientific test in Massachusetts and in Arkansas. And his argument was that Dr. Clark's test showed that children who attend integrated schools like in Massachusetts actually resent their race. And that it's not the children that, as Dr. Clark now is seen to be running away from, is not, as his test showed, that the children of Arkansas embrace their color. And so, it's hard for me to understand why the Supreme Court would embrace something that has been contradicted by Dr. Clark's own test. And so that became the real basis. That became
Make you wonder what's up with the Supreme Court.
Right, make you
what
wonder.
Were they trying to do? Because you're talking about basically the Supreme Court using what they refer to as the confirmation bias or confirmatory bias, where they do these so-called tests extract the information that that validates their pre-existing conclusion that blacks are inferior and they know it, and use that as a basis for establishing a decision that really shouldn't be based on any of that, because we're talking about whether or not a person, in theory and in law, in the practice of law, should have the right to go to any school. And you're saying, and what you're doing is saying, well, we got to let them in on account of they inferior and they know it, which has nothing to do with what we're talking about in the first place. It's just insulting.
Right, it is. And see, this is one of the real problems. Nobody went back and really searched Thurgood Marshall's background.
Oh, good.
Because you see,
Good.
Thurgood came out of Baltimore, Maryland.
Right.
And he actually wanted to go to the University of Maryland.
Right.
But before he did that, he went to Lincoln University in Pennsylvania. And Lincoln, at the time Thurgood got there, had no black professors. 0 black professors. And all these young, bright minds were being taught by people actually from Princeton. So Princeton had a large impact on the way that studies were taught at Lincoln. And Princeton was actually the Confederacy primary school in the Ivy League, because the Confederacy wanted their own children to actually have an Ivy League credentials, but they didn't want them to go too far into the North to get it. And that's why Princeton is located in southern New Jersey,
Right.
Near, the Mason-Dixon line and all of that. And so in that, then the policy became that we're not going to teach black children who go to Lincoln, to be taught by black professors. And so at some point, those students said, well, look, why can't we have some black professors here? We put a black college. And Thurgood led the struggle to prevent black professors from being admitted into Lincoln University. I mean, that was his thing. In his sophomore year, he actually led the fight to prevent blacks from being teachers at Lincoln University. So, in his own mind, he had this belief that these white teachers would actually be better.
Right.
So it was easy for him to hook up with Dr. Kenneth Clark, and then began to push the Supreme Court toward that, which is now what you were talking about today, where you have a lot of young people who are the victims of mental side.
Right.
All right. In the sense that, they don't want to necessarily be called black.
Right.
They don't want to be dealing with black.
They are vehemently opposed to you calling them black. They will explain all the many reasons why they are not black, and then we'll go nigga, all over the radio, all over the record, have white people call them this.
Right.
I mean, this is just strange to me. How you are so comfortable with this, and so vehemently opposed to somebody suggesting that you are somehow connected to Africa.
Right.
On the other hand, it's weird to me.
No, and it's frightening. And, and what it does, we fail to realize that more than anything else, the Supreme Court is really a think tank. And so they're not just here to receive briefs from different sides of the aisle, but they're here to really think about what public policy we need to set for the country. And when do we need to set that public policy? And so now, we're in a situation now where we have Clarence Thomas in the Supreme Court, and, it can't get any worse.
Right.
I mean, because basically, when you go back and look at Clarence's background, see, and these backgrounds are very important. Clarence grew up in Georgia, but he was taught by all white Catholic nuns.
Right.
And then he left there and went up north to a Catholic school.
Right.
And then from there he went on to Yale. But his mind has already been made up, as to how black looked to him, and it didn't look good at all. And when you look at how Clarence Thomas got into the Supreme Court, he had to end up doing his own people in before he got into the Supreme Court.
Correct.
You know, so now we're dealing with that kind of scenario. Whereas on the other hand, I bring out that, you know, in the early 1900s, where you had the lynching of Leo Cobb, Leo whatever, in Georgia, in Cobb County, Georgia.
In Cobb County.
Now, as a result of that, Louis Brandeis became the first Supreme Court justice who was Jewish. Now, his thing is that I'm a Zionist. And so when they put him on the Supreme Court, it was to stop that lynching that had already happened in Georgia, all right? And so, you know, they understand that when you want to bring about an end to something, you have to put somebody in there with a sword. All right, and not with a peace pipe. You know, as Clarence Thomas is sitting up there doing, smoking a peace pipe. So, you know, we're not really as involved as we should be in how these decisions are being made and how they really affect us as a people.
How did, and this is speculative, you know, and I probably shouldn't even dwell on it too much, but I'm going to ask you, how does a person like Clarence Thomas, who, like you said, went to Catholic school, although the Catholic school was not a white institution, he was just taught by nuns, you know, and that does have, I went to Catholic school, and I was in Harlem, so the phenomenon is daunting. But you go from that, and unlike Thurgood, ain't nothing high yellow about Clarence Thomas.
No, ain't nothing.
He goes to all of these places, these white institutions, and ultimately he is sworn into the Supreme Court. And when he's in the Supreme Court, he has to be confronted by the reality that on the one hand, you have Clarence Thomas there thinking that he is some sort of honorary white person and that among the educated elite, there is no color. And he is confronted with an Antoine Scalia, who basically, by every aspect of his entire career, especially that on the Supreme Court, he is saying, no, you're not, nigga. I wonder, how does a person like that deal with that contradiction, where you've pulled up to the bumper, and now everything you took with you, everything you used to get there, is suddenly thrown in your face, and you are confronted with the system that says, Negro, please.
Well, you know, one of the interesting thing about Scalia is that he happened to be the first Italian on the Supreme Court. And so, you know, not the first Catholic, but the first Italian, all right, on the Supreme Court. And you know, a lot of times, it's just like with Roger Taney. Roger Taney was the first Catholic on the Supreme Court, and he ended up writing Dred Scott. And so now you have Scalia, who happened to be the first Italian. So these people have a lot to prove, you know, in terms of the good old boys network.
And Catholicism, especially Roman Catholicism, is imperialistic. It's just imperialistic. It's a pecking order, castles and pecking order type religion.
Right. You know, and so now when you look at all that really sort of help you understand, you know, how Clarence Thomas and all these people, Scalia and all of them, really developed, because, you know, now Clarence is taking an inferior position to Scalia.
He has. I mean, he's like the quiet. Don't make no way. He's not assertive, dynamic one way or another in the Supreme Court.
No, as a matter of fact, the only time that he ever got assertive in the Supreme Court before Scalia died was when you had a cross-burning case in Minnesota. and the parties there, the plaintiffs there, the grievance, were actually biracial, interracial rather, and now you have a situation where you have this cross burning in Minnesota. Now, when Clarence and those got that case, a cross burning case in Minnesota, well, they said, well, this is really a First Amendment right. The Klan and those who were burning cross would only have expressing their own free speech, in case like this. So, we can't really violate their free speech rights. All right? Now, so that went on. And then 2 or 3 years later, they got this case in Virginia. Yeah. And when they got the case, it went to the Supreme Court, and Clarence sounded like Malcolm X. Because Clarence married a white woman. Yeah. All right. Yeah. So he got on the bench for the first time. He started sounding like Malcolm X. He said, "Not in my backyard." All right. You understand? And that's why the Supreme Court reversed itself on this cross-burning case because of Clarence Thomas' personal views or personal interests of protecting his white wife. Right. All right. Now, when going on in Minnesota, it was fine, but when it got to Virginia, where he lives. He lives in Virginia, and his wife, they both there, and they burned across.
You're saying it was more of a hit dog phenomenon.
It was that, you know what I mean? So right, absolutely. So that's why I'm saying how you have to really get into the legal history of these cases. Right. Because we fail to, none that's reported. Right. You see, unless you get caught up in the legal history, that's why the Supreme Court is always a very important institution, and it's also very important to really review the decisions of the Supreme Court. And we don't spend enough time doing that. We don't do enough time with the background checks, with the facts that are not reported in the decision. We don't do none of that. And we just embrace these decisions to our detriment.
Right. We're kind of running out of time, and we're gonna continue to bring Attorney Alton Maddox back to 30 frames a second because he is first of all unique. He's almost like the last of his kind, and that is unacceptable because we need his kind of dynamism in our community. You were contacted by, we only got like a few minutes, less than 5 minutes, 3 or 4 minutes. But you were contacted by someone in regards to the Orlando massacre. As of the 28th, you're gonna start looking out for people in the way that Alton Maddox was born to do. Tell us about that, but I also want you to mention the fact that, and a lot of people just overlook this, but this wasn't just a gay nightclub. This was a gay nightclub on Latino night, So a lot of the people who were massacred in that shooting were not merely gay. Most of them were gay Latino.
Right, absolutely. And why this is important. I'm actually on my way today to the homegoing services, in Brooklyn, So, but I have not tried to get overly involved in this case until after these services are over with, because I'm sorry, respecting the family rights to, to have those services and all of that. But there's a lot of questions to be raised, and the media has not raised them. Correct. And there has to be some real search and an investigation into what this is really all about. And Correct. It's not as easy as one sounds. And so the argument that I make is that, first of all, we're talking about hate crime here. Right. We're not talking about, the terroristic threat, what goes on in Afghanistan or whatever else. We're talking about hate crime right here in this country. And we have a responsibility to look at that, and we have a responsibility to make sure that others that do not blow the whistle or fumble the ball, you know, in a way that is
or
not
pretend like
right,
it doesn't
exist.
Right,
you know what I mean? So therefore, you know that. But more importantly, on June 28th, which is really the day that I had told the Attorney General of New York State, as well as the District Attorney in Brooklyn, is that on that case, on that date, there's a case called People of Thutmose Road.
Thutmose, right.
That's going to be, and it's going to be in the King County Supreme Court.
Right.
So I will be in Brooklyn that date because you see, I know that I have never been disciplined. Period.
Right.
Now, what people saw, it was a figment of their own imagination.
Right.
But I have never been disciplined. Now, I welcome the fact of somebody putting handcuffs on me, and let's try this case
That'll
first.
be interesting.
All right, you know, let's try the case. You know, because now the public have a right to see exactly what happened. Exactly what happened. In a way that we never had a chance to do that. Because you see, as a lawyer, you're not entitled to a jury trial. Mm-hmm. You see, so even if you have some claim, it has to be presided over somebody else.
By the kangaroos.
Right, by the kangaroos.
Yeah.
So, but now I got an extra opportunity to be tried in Brooklyn with a jury of my so-called peers.
Right.
All right, and so that becomes a very critical moment for me. And after that, this whole thing in Orlando becomes a secondary but serious matter because you see, I tend to believe that Black Lives Matter only when white folk go to jail.
Right.
Okay.
Right.
And Trayvon Martin's life did not matter because George Zimmer is still out here.
Right.
All right. And until we put Zimmer behind bars, where he is going.
Right.
All right. You know, we all this stuff about Black Lives Matter is just a facade.
Right.
It's just a ceremony or ritual. You know, but it has no real meaning.
He doesn't even have the decency to like. Be quiet.
No, absolutely not. You know what I mean? I mean, because if maybe he had been quiet, we'd let him go.
Correct.
All right, but since you're not quiet, you're not going to do it.
He will not let you forget him.
You're not going to pat yourself at us,
Right,
you know,
right.
and we're going to take it.
Right,
I mean, at least I'm not going to take it. You know, now the rest of the class decides to do what they want to do, but I'm not going to take it. You're not going to pat yourself at me.
Right.
All right? You know, and the rest of the people can take it and do whatever they want to do.
Right. Okay, you got about 10 seconds. Tell us what we should do, what you're going to do.
June 28th in Brooklyn, Kings County Supreme Court, People versus Clark, a young man who had autism is going to be prosecuted. It is very important that we as a race, as a people, recognize that this is an unjust prosecution, and that I believe the family here had the benefit of Charles Pitts talking about autism beforehand, and we're going to see what happens. But it's June 28th. Circle that on your calendar.
Peace. We'll see you next week.